This is Law and Society. It's where legal and social issues come together. Andrew Stevenson is our attorney at law, stevensoncriminaldefense.com. And today's topic is a good one. It's about intent and character evidence. And before we took the break, the note was drugs and guns do not mix.
Drugs and guns are a bad combination.
Right.
Yeah.
So let's continue our discussion on intent here. And I guess the next thing is, how do we prove intent?
Right. How do we go about finding what somebody really wanted to do, or what their plan was, or why they did what they did?
Mm-hmm.
The number one most common is that our suspect or client tells somebody. Most people assume that when you say why you did something, that they will believe that's the answer. Mm-hmm. And so we find that in the police interview, which leads us back to our number one rule, which is it's best not to speak to the police without an attorney.
Right.
Sometimes we tell family or friends. Now, in today's world, what we find is intent is being really derived a lot from the phone. We send a text message, we send a tweet, we send a Snapchat, we send an Instagram.
Anything in advance of the crime?
No, either before or after.
Oh, okay.
Afterwards.
Oh,
yes.
Okay.
We may see somebody says, "Oh, I'm sorry." They may say, "Yeah, you're right. I probably shouldn't have done that." Mm-hmm. Or, "Oh my, I just effed up, and what am I going to do now?" So people's intent is really being derived a great deal from the phone. And that's why the police want that, and that's why what you say on your phone makes a difference.
Leads us back to that episode we did about
the phones,
and the amount of evidence that can be gathered.
Correct.
And by the way, if you're listening and you want to reference any of this or want to listen, you can go to Andrew's website and listen to any of these shows, and they're by title. So I suggest. It's a good lesson series. Put them on an iPod and podcast them to your kids.
The other way that we figure out what somebody does is we can infer it from the behavior in some circumstances. If the person goes to the gas station and fills up the can full of gas, and they go to the house and they sprinkle it all around the living room, and then they light the match and they toss it as they're walking out and send the Instagram picture of it as it started, their behavior demonstrates that was intentionally arson.
Right.
And that the furnace didn't just randomly go off. And then the last one is really where a lot of the debate comes, is when the client says to me, "Yes, I did this, but I didn't intend that result." Or when they say, "I would never do anything like that. I've got 50 character witnesses who will come in and tell you I'm not that type of person." And so this is when we get into character evidence. And character evidence is really one of the more complicated conversations I sometimes have to have with clients, because I appreciate that anyone who's accused of something which is out of their normal behavior or their character would want to be able to say to a jury, "Hey, I'm a good person."
Yeah.
Bring in witnesses to talk about how I volunteer with kids, how I am a member of my church, how I'm on the school board, how I mow my lawn, how I help my neighbor and mow their lawn too.
Right.
All of these things about us, we would love to be able to come in a trial and share, because we would hope that a jury would believe, well, he's a good person, and good people, quote, don't do these types of things, and therefore he probably didn't do it. And it makes sense that that's how you would want to proceed. That's character evidence. The problem is the law doesn't like it. The law really generally doesn't like a whole lot of character evidence. And so it tends to exclude it. And the first type of character evidence that it excludes is what is called propensity. And that works both ways. And what propensity means is if somebody has done something in the past, therefore we can want to infer that they did or did not do it in the present.
How many times have you seen in a case, whatever the case is, where they go interview the neighbors, and the neighbors all say, "Oh, he was such a nice, quiet man. I can't imagine him doing something like that." I mean,
it does happen.
That's
a lot,
that's that whole character thing. I can find 10 people to say Mark's a great guy,
and then you can go find 10 people who are going to say Mark's not a great guy.
Yeah, exactly.
And so what the law says is they don't want to fill up the courtroom having a debate about whether Mark's a good guy or Mark's a bad guy, because in the end it's going to cancel each other out.
But propensity, we talked about this before going on today. I didn't realize this, that a person's prior criminal history cannot be brought into a current, if they're on trial for something currently, they can't.
Correct.
If they were convicted previously, that doesn't come into evidence.
It doesn't. And it's one of the things that most people get shocked about. Well, how could they let this person who's done this 5 times before go free, so to speak? And the general rule is this, is that a prior conviction of a criminal defendant, someone who's charged with a crime, cannot be introduced at their trial with 2 exceptions. The first exception is if the client testifies. So as soon as the defendant or the client gets on the stand and wishes to provide testimony, whether it be about their version of the events or whether it be they want to say what a great individual they are, then if they have a prior conviction, it can be used to impeach them or to challenge their credibility.
Yet another reason why your best advice to the defendant is you're not going to testify.
That's part of the reason why a large number of people do not testify. And then the second example of when it can be introduced is to show something other than a propensity. So and I use this as an example, if a person's on trial for robbing a liquor store and they have 9 prior convictions for robbing a liquor store, the prosecutor can't tell the jury that they have 9 prior liquor store convictions, so that the jury thinks, well, he did it 9 times in the past. He
must be guilty this time. Yeah.
But they can if it shows something else. For example, if the current liquor store robbery, the person wore a clown nose, which is a way of preventing eyewitness identification, because all you see is the clown nose.
Right.
And if the prior 9 times this individual was convicted of robbery, they wore a clown nose, then they would be able to introduce the clown nose to prove that it was his identity and things along those lines.
So in that case, that becomes the identifying characteristic.
To prove it was, in fact, him.
Right.
Because the eyewitnesses would not recognize
Would
him.
that also go for a particular brand or type of firearm if they used the same firearm over and over again?
Or a potential style to,
Right.
the way it was done.
I was thinking of, we had the .22 caliber killers. Their trademark was using a certain type of gun.
Yes.
That can be used for identification. But only if there is something that proves that or goes to prove that identity.
Right. So then the question becomes: so what is allowed?
Right.
And it's interesting in criminal cases, a client or defendant's character, the prosecution can't introduce it unless the defendant starts the battle, if you will. So if he's done a lot of bad things or is not a good person or nobody likes him, the prosecutor can't call a bunch of witnesses to say, well, he cheats on his taxes and he never takes care of his property and he got kicked out of the out of the lodge for being late and never paying his dues. He can't get into any of that unless the defendant wants to start by saying, hey, I'm a great person. And I would never do anything wrong, and I haven't. And I've led an exemplary life.
And that opens the door then for them to
cross it. But what you generally are allowed to introduce are things that are pertinent traits that are related to the crime. So, for example, if it's an assault case, you could bring in witnesses who say, I've known John for a very long time. In my opinion, he's one of the calmest, kindest, gentlest individuals. I've never seen him lose his temper. I've never seen him raise his voice. He's not the type of person who would provoke a fight. Right. That's the type of character evidence that the law kind of would like to have and allows and it encourages. But you can't talk about specific instances and you can't get into general, well, he's a good guy type stuff. It has to be a very relative and specific character trait.
I can think of, and again, I have a friend, distant friend, who actually got charged with assault one time. And he didn't hit, he didn't punch, he didn't kick. It was a kind of a land dispute, and he wound up touching the guy's shoulder, and the guy had him charged with assault. And I think it got dismissed ultimately.
I think it probably got dismissed too.
But it tied up. The sheriff actually had to arrest the guy for assault because he physically touched the other individual. That's what I was told anyway. Yeah, the guy went through some gyrations.
Yeah, it may have been different back then, but assault today requires that you have an intent or attempt to cause physical harm.
Okay, really? Okay, back to intent.
Back to intent, yes.
You had to knowingly
you have
or
to
recklessly or negligently.
Yes, you have to knowingly attempt or to knowingly cause or attempt to cause physical harm.
Gotcha.
So, shaking somebody's hand, not assault.
Right.
Patting somebody on the back, not assault.
Okay.
Hey, how you doing, buddy? You come up and kind of slap them on the back, not assault.
Even if it hurts a little, that's
now,
not.
if you hit them so hard that you actually cause, but then you come back to the question, well, did he intend to hit him that hard, or did something else happen?
Right. Right.
And that's why you get into the intent. Did they knowingly do that or not?
Let's talk about some of the back to this whole character idea and witnesses. What if your witness has a little bit of a checkered past? Is there anything you can do to discredit the witness?
You can. Now, if it's a witness who gets on the stand who, let's say, wants to testify for the prosecution.
A jailhouse snitch of some sort.
Snitch, yes.
Yeah.
Who's there to say, oh, I saw Johnny down at the jail and he was bragging about what he did.
And we were cellmates.
And we were cellmates, and he couldn't help but confess.
Right.
And his confession exactly matched the police report that I happened to find in my cell. Anyways, when he gets on the stand and it turns out he cut a very nice deal and is now getting released, yes, the defense attorney, I would be able to cross-examine him about his prior convictions, if they're felonies, or any crime that deals with veracity, which is truthfulness. So if he'd been convicted of, let's say, theft, if he'd been convicted of falsification, lying to the police, all of these things, and I've had a case where that's what it was. The jailhouse snitch, unfortunately, the prosecutors, they don't pick them. They tend to emerge out of the jail on their own.
Yeah.
But this guy's record for falsification and theft was numerous, and they didn't even bother to put him on the stand, even though they disclosed him. Yeah.
And again, we've talked about the rules of what's allowed in terms of inside the jail cell and where you have.
You're going back to whether or not the police can use a confidential informant. Yeah, actually they can.
Yeah, they can. That's
they
right.
can. The police can actually use a confidential informant to put in there to get you to confess to the crime to your cellmate.
All right. The last thing on your sheet says fun story. Tell us a story, Andrew.
Well, I can tell you the story that we were talking about before we went off air about character evidence.
Yeah.
And I had a client once who was adamant about wanting a trial. They wanted to go to trial, but I had noticed that they had some tattoos. But I had looked and I saw that I could cover up most of them with a long sleeve shirt and a nice colored shirt. And I said, listen, I'll be glad to do a trial, but the next time I see you, no more tattoos. Okay, we've got to end this pattern, because every time I saw him, he seemed to be getting more and more and more. So it came to a couple of days before trial, and as our final meeting to decide whether or not we were going to resolve the case or have a deal. And he shows up at the courthouse, and I walk in, I take one look at him, and I leave. And I go back over and I walk up to the prosecutor and I said, what's your best offer? And the prosecutor gave me the best offer. I walked back to the client and said, here's the deal you're taking. And then everyone asked, well, why? I said, well, he'd gotten a new tattoo and it happened to have been of a swastika on his forehead. So that's an example of character evidence, which we're just not going down that road in a courtroom. So you never know what you're going to get, but character evidence does come into play.
That's too funny.
And that's what happened.
Well, that's just visual. That's just like,
but it's a statement of his character and who he is.
Yeah.
And it usually doesn't play real well.
All right. We are out of time again. Our topic today, intent and character evidence. If you want to hear any of this or, play it for your kids so they know how to stay out of trouble, you can go to StevensonCriminalDefense.com and we'll cross-link the show. And again, you've been listening to Law and Society, where legal and social issues come together. Thank you, Andrew.
Thank you.